We don't want to reflect what the National Party did under apartheid and what the Nazis did in the 40s.
Needed research that actually affirms your view. As I've just heard you saying that you don't even know where the minister actually came up with these numbers.
Yeah, well, we don't know, but we have tested it. What's happening, what we're doing in the Western Province, which is under a Democratic Alliance government, we've brought the unemployment down to below 19% compared to the 42% on the national basis.
How? And I mean, Michael, you and I know it's not reflective of the current reality in our labor force.
Quotas for each particular race group. We've got all sorts of problems that arise out of it. For instance, do we introduce a new race register in South Africa? And God forbid, we don't.
Guys, so the more I'm studying South Africa's politics, the more I'm beginning to realize that at the end of the day, it seems that South Africa's history might continuously still be retold as, one where, a portion of community, society that is termed disadvantaged is trying to get into the upper echelons of, the control of the economy that many argue is still held by white people in South Africa. And so this is actually what I'm beginning to see as this whole argument between employment equity. So this new Employment Equity Act, which DA's Labour spokesperson Michael Bagraim has actually been vociferous speaking about. I listened to one really interesting breakdown by one counsel in an employment office. His name is J.J. Van der Walt, trying to break down this whole thing about the law, saying that, I think this is today now, Tuesday, the 6th of May, the DA will be taking this whole case to court, all right? So he argues that, some parts of the of this new Amendment Act that the DA is trying to challenge is the fact that, the Department of Labor is trying to set numerical targets, and that this is a challenge, setting numerical targets, saying that employers now must develop a new equity plan, all right, in 18 sectors, I think, that have been identified by the Department of Labor. And that each of these sectors now will now have a 5-year sectoral numerical targets, all right? And that the new law is actually, according to him anyway, he argues that the new law is actually supposed to take power from the employer to set their own targets and give this power now to the Minister of the Department of Labor, who will now manage that whole that whole target. So this is a major fight the DA is trying to argue. They argue that, 5 years has actually been given to give this to attain these numerical targets, and I think the aim of is to target the big companies in South Africa. So employers that employ 50 employees or more would be hit harder, because right now they would need to undergo what this whole bill calls deeper transformation, all right? So in other words, it says that the bill now, this new amendment, right, is a bill that introduces a compliance certificate which guarantees meaningful participation in tender processes, all right? So there's participation in tender processes, but now there's meaningful participation. And so if these companies that have actually been designated the targets, of this bill are not compliant, in other words, if they do not have a compliance certificate, then it's actually been argued that, then it had not put in an employment equity plan, all right? It hadn't implemented its employment equity plan, then it cannot participate in tender processes, all right? And that means it won't also meaningfully participate in tender processes, all right? So let me just go back quickly again. It says that the new bill, according to this J.J. Van der Walt from the Cliff Decker Hofmeyr Incorporated, I think it's a counsel in the employment law practice, all right, he's actually arguing that this new bill mandates that every company now that has been designated a target, and I think these are the big companies that employ 50 employees or more, from I think this is now from the end of May, thereabout. But anyway, yeah, from the 15th of May, all right, from the 15th of April, it made compliance necessary. All right, what is this compliance? It says compliance, these companies must have a compliance certificate, all right, which shows that it had implemented an employment equity plan. Now, this employment equity plan is what would then, this compliance certificate anyway, and the employment equity plan would now determine how much the company can participate meaningfully in tender processes in South Africa. So in other words, if it doesn't have a compliancy certificate, which means that it had not implemented an earlier employment equity plan, it might participate in tender processes, but it would not meaningfully participate in tender processes. So these are the problems. And at the end of the day, he argues that previously, most of these companies which didn't set up an employment equity plan, for example, were threatened with a fine, which they were willing to pay. But this time around, it actually seems that they have been mandated now that if they do not have this compliance certificate, they would not take part meaningfully in tender processes. And so this is actually, the DA, the basis for the DA challenging this whole employment equity, act, the amendment to the act, arguing that, it's been 20 years. South Africa has been experimenting with this whole thing with what Michael Bagraim calls social engineering, arguing that, the Nats tried it and failed. Now it's been 20 years that the ANC has been trying it and it has also failed. And rather than, continuously trying something that has failed, they want to try to push for some other policy that allows the growth of the economy. And the DA argues that, in pursuing the growth of the economy, then probably there could be a different way to manage what many have complained is a reflection of only white bosses at top management positions in South Africa. So this is the basis of the problem now, and to be heard in court today. So I was really interested to really hear from the Labour Department, deputy. He's actually the acting deputy at the Ministry of Labour, Tembinkosi Mkalipi, to really understand what is it that the Labour Department articulates, about this whole thing with employment equity in South Africa and how they see it. And let's just quickly listen to how Labour sees it before I come back to how Michael Bagraim slams the whole act as an attempt at social engineering. Michael Bagraim argues that South Africa is sitting at 42% unemployment rate, and that this kind of law, for example, is not necessary now in a country with this level of high unemployment, because right now what the economy needs is growth rather than this attempt at social engineering. This is the DA's position in this perspective. Now, let's quickly listen to this guy from the Department of Labour help us understand what it is that the Department of Labour exactly wants, and we'll be back with Michael Bagraim.
The Employment Equity Amendment Act, what is it meant to achieve? Section 15A and its intended purpose.
The intended purpose of the changes that we are making in the law are that we want to make sure that companies comply with the law as it is. If you look at the progress that has been made in the last 26 years, employment equity has not reached the standard that we expected to reach. And the reasons for that is because we believe that employers have not been committed to making sure that employment equity is implemented. Yeah. And as a result of that, we've taken a decision, and we went to Parliament to have this debate, a policy decision, to give the minister powers to be able to set up targets, obviously in consultation with the different sectors of the economy. And the reason for this is simple, is that we have not seen the expected progress on transformation in the labor market for the last 26 years.
For a person who may not be au fait with the South African landscape, and I'm going to say an investor who is unaware of what South Africa's history is, how would you explain the legislation of employment equity in simple language? What is its primary purpose?
The primary purpose of this legislation is to ensure that the labor market, the companies that do business in this country, reflect the society that they work in. I mean, any investors, whether they're coming from America, whether they're coming from the UK, they will see an absurd situation if in the UK, the majority of the people that are heading companies in the UK are made of, for example, of Chinese, not people from the UK. I mean, this is a situation in South Africa where the majority of the people of South Africa are not reflected in the companies that are operating in this country. And any investors that want to invest, there's no doubt that investors will understand that, wherever they come from. We don't think that is going to create any problem for investors to come in, because this does not say that investors must appoint or employ people who do not have the skills, who do not have the know-how to do the job. It says only that in your employment processes, you must make sure that in this law, in this country, there's an Employment Equity Act that says there's got to be transformation of the economy and the companies that operate in the economy.
Yeah. So, in other words, Michael Bagraim is actually arguing that, this is what the Labour is actually trying to push for. But then they have a problem with clause 15 that says that employers must reach certain quotas. Otherwise they will get massive fines, all right? And, Michael Bagraim, the DA, thinks that this is actually another attempt at racial engineering, because it actually pushes for these quotas. He actually speaks about how, if probably South Africa is going to another form of race registers, all right? He actually thinks that, South Africa really needs a, redress for the racial attempts at racial engineering by the Nats, previously under the apartheid regime. But then the DAs, especially with Michael Bagraim, arguing that they cannot do that again with another form of social engineering that, this whole Employment Equity Act amendment, so to speak, is actually trying to introduce. And then at the end of the day, that whole section of 15A would always be problematic, especially to the DA's vision of jobs. So in other words, this new Employment Equity Act would actually be a big problem, because it's actually at the foundation of it's actually striking at the foundation of the vision of the DA to increase jobs, or to increase the number of jobs in South Africa and to grow the economy. So we're seeing clashes in this GNU, and I don't know how long the DA and the ANC will continuously struggle, because right now we are beginning to see that their vision, the ANC wants deep transformation in South Africa. The DA wants an economy of jobs and growth, that can actually fight the high unemployment rate of what Michael Bagraim argues is 42%. And even if you add the youth, he actually argued somewhere that, the unemployment rate might even be actually getting to 70-something%. All right. So how the DA and the ANC will continue in this kind of GNU is really, really problematic. But let's quickly listen to Michael Bagraim break down some of his arguments on the problems he sees with this, Employment Equity Amendment Act, and share your thoughts in the comments.
Today, welcome, sir. So tell us all about what necessitated this court action on the DA's part.
Thank you. Yeah, we've not been in favor of social engineering for many years, and everyone who watches the political scene will now understand that. We don't want to reflect what the National Party did under apartheid and what the Nazis did in the 40s. What we want is to grow the economy, and we want to ensure that more jobs are created. We're sitting at 42% unemployment. In fact, in some places with the youth, it's almost 70% unemployment. So it can't be business as usual. We've had the equity legislation on our statute book for over 20 years. And for that time, it's growing worse and worse. It just hasn't worked. And if we want to do the same experiment time and time again, just try and make it harsher, it doesn't make any sense whatsoever. Mm-hmm. So now what the minister has done, and it's not Minister Meth, it was the previous minister who introduced this under 15A, has put in actual exclusive quotas per industry, and has said that you will reach those targets, otherwise we're going to give you massive fines. What that means is that the business community is either going to close up shop or stop employing, or in fact seek elsewhere, seek better climes. Now, we don't want that. What we want is we need to start working on the economy, we need to start working on our education system, and we need to look at how we can actually create more jobs for everyone. It's not a racial engineering this, it's for everyone. Every single family in South Africa, whether you're white, black, Indian, colored, they're all suffering from this. So what's happened is, with this exclusivity of quotas for each particular race group, We've got all sorts of problems that arise out of it. For instance, do we introduce a new race register in South Africa? And God forbid, we don't want to see that. We don't want to see what was done under the National Party. And we believe strongly that if in fact we actually grow the economy, that we will reflect the demographics of South Africa. We will reflect it. We don't stand in the way of redress. We are a party that agrees entirely with the Constitution of South Africa. It's a forward-thinking, fantastic constitution. The Constitution says we must seek redress for the wrongs and the ills of the past, and in particular the ills of racial engineering that took place under the National Party. So we need to seek that redress. Now, if the legislation is not giving us that redress, which we can see is happening and won't happen under the social engineering that is now wanting to be introduced, if it won't happen, then we're actually breaching the Constitution. Now, this is a blunt tool that the regulations are giving the minister. We don't know even if it was scientific to set those targets. He just said, she just said, and the previous minister, he just said, that they consulted. We don't know with whom, how, and what did they do. They had a few city hall meetings and consulted, I suppose, with, you know how these meetings work. You have a group of people, you bust them in, you say, this is what we want to do, and you hear some clapping, and we say, we've now consulted, we're now setting the targets. But the business community are saying, it hasn't been scientifically done, it hasn't been done with a forethought as to what our industry is, where we are, what qualifications we need, etc. What's happened, of course, and this is the argument that we're hearing from the ANC, is that there's a weighting of white, pale male in the upper echelons of the business community, which is true. But it's going to take time and a lot of hard work. Our government has to do a lot of hard work to actually reflect the demographics of South Africa.
Michael.
And it will happen. It will happen, but we need to make it faster. We need to make sure that it's people that have the ability and that are fit for purpose to go in. I'm hearing from everyone that, yes, there is legislation right now.
Yes.
That if someone says they are somehow discriminated against because they're black or female or disabled, we've got legislation that that person can come forward and challenge it.
All right.
As a labor lawyer, I've been practicing for 40 years, and in particular the last 20 years, I've had a handful of cases where people have come to me and said, I've been discouraged from getting that job or
But
from
Michael,
a promotion because
Michael,
I'm black or because I'm colored, Indian.
Michael, sorry,
female.
for the interest of time, Michael, I'm sorry to get in there. Look, I mean,
No problem.
Look, I mean, what are you counter-proposing then as a more viable option with the minister? And have you tested this theory and conducted the relevant employment, labor equity, feasibility studies, as well as needed research that actually affirms your view? As I've just heard you saying that you don't even know where the minister actually came up with these numbers.
Yeah, well, we don't know. But we have tested it. What's happening, what we're doing in the Western Province, which is under a Democratic Alliance government, we've brought the unemployment down to below 19% compared to the 42% on the national basis.
How?
And that's bringing it down even subject to the national laws. And how we're doing it is we're looking at deregulation, getting rid of red tape, trying to act as an intermediary between those seeking jobs and the business community. And the government, the local government, the provincial government is helping the business community to try and place people in that position. And a strong viewpoint, and it's a strong test, we've had now 5 years of this, where we've actually halved the unemployment. And in halving the unemployment, we're showing the equity figures getting stronger and stronger. So you can't say we haven't tested it. It's tested, it's been worked. It's still no good. It's still no good. 19% unemployment is no good. We need to go down to 3-4% unemployment.
All right.
But we got to keep trying.
Absolutely, Michael, because I mean we know that of course you're also saying that this section actually violates, I'm talking about section 15A there, violates section 9 of the Constitution that guarantees equality before the law. But I mean, Michael, you and I know it's not reflective of the current reality in our labor force, I know, but unfortunately we have to leave our conversation there. Hopefully we can take it further at some other point, Michael. Let's leave it there for now. That is Mr. Michael Bagraim.